Hello, welcome. If your green card case depends on the wrong filing chart this month, you could lose time that is hard to recover. In July 2026, some applicants may be able to move ahead sooner, but only if they use the correct chart, submit complete forms, and prepare for tighter review. In this video, I will explain the July 2026 USCIS Visa Bulletin and NVC updates, who may benefit, and what you should do now to reduce delays. This is general information only and not legal advice. If you find this update helpful, please subscribe, turn on the notification bell, and like the video so you can receive immigration updates on your smartphone. Now let's get into the video. The first important update comes from USCIS. For July 2026, USCIS has confirmed that all family-sponsored preference categories must rely on the dates for filing chart from the Department of State Visa Bulletin for adjustment of status filings. This matters because the dates for filing chart can sometimes let eligible people inside the United States submit Form I-485 earlier than they could if USCIS required the final action dates chart. For family-based green card applicants, this can be one of the main ways to move forward sooner. If your category is eligible, your priority date is earlier than the listed date, and you are otherwise eligible to adjust status, you may be able to file the adjustment of status package before final approval is available. That filing step is important. Filing Form I-485 does not mean the green card is approved right away, but it does move the case into a more active stage. For many applicants, filing I-485 can also make it possible to submit Form I-765 for a work permit and Form I-131 for advance parole, depending on eligibility. So when people ask how they can move faster, one answer is to check whether the July 2026 family-sponsored dates for filing chart allows filing now. Many applicants lose time simply because they do not check the right chart or do not understand when they qualify. But this is where applicants need to be careful. You cannot file only because you want to move faster. You must be eligible. You must review your exact family category. You must check your country of chargeability. You must confirm your priority date. And you must make sure USCIS is allowing the correct chart for that month. In July 2026, family-sponsored applicants can use dates for filing, but employment-based applicants must use the final action dates chart. That means employment-based applicants face a more limited filing situation this month. So, the faster path is not the same for everyone. The second important update is the July 2026 Visa Bulletin. The Visa Bulletin controls when family-sponsored and employment-based applicants can move forward based on priority dates. For family-based cases, the July Bulletin brings some important filing chances. One of the strongest family signs is that F2A is current under the dates for filing chart. F2A includes spouses and children of lawful permanent residents. For spouses and children of green card holders, this is an important category to watch. If you are in F2A and inside the United States, you should check whether you may be eligible to file adjustment of status. If you are outside the United States, the dates for filing chart may also matter for NVC document preparation, depending on the stage of the case. But again, the key point is preparation. A current filing chart does not help if your documents are not ready. It does not help if your forms are incomplete. It does not help if your passport is expired. It does not help if your financial sponsorship documents are missing. Faster movement only helps applicants who are ready to act. The third important update is from the National Visa Center. NVC's July 6, 2026 update shows that document review is moving. NVC says that as of July 6, it is reviewing documents submitted on June 10, 2026. That means NVC is actively reviewing cases and moving some applicants toward documentarily complete status for consular processing. This is one of the most important parts of faster visa approval. Many people think the delay happens only at the embassy interview stage, but many delays happen before the interview because the case is not documentarily complete. NVC cannot move a case forward if fees are not paid. The DS-260 is not submitted. The affidavit of support is incomplete. Civil documents are missing, or uploaded documents are rejected. So, if you want faster visa processing, The first step is making sure your NVC case is complete, accurate, and clean. If NVC asks for a correction, respond carefully and quickly. Do not upload the wrong document again. Do not ignore the message. Do not submit unclear scans. Do not leave financial documents incomplete. Every correction cycle can slow the case. For immigrant visa applicants abroad, the faster path is usually not about shortcuts. It is about avoiding mistakes. Pay fees early. Submit the DS-260 correctly. Upload the right civil documents. Make sure the sponsor's tax documents are complete. Make sure the affidavit of support matches the household size and income requirement. Check embassy-specific document rules and keep the passport valid. The fourth important update is interview scheduling. Even after NVC accepts documents and marks the case documentarily complete, the interview still depends on visa availability and embassy or consulate capacity. This is why some applicants receive interviews sooner than others. One embassy may be scheduling recent documentarily complete cases, while another may still be working through older backlogs. So if you are waiting for faster visa approval, you need to understand your embassy's situation. NVC may finish document review quickly, but the embassy must still have an open appointment. Applicants should watch the State Department's immigrant visa scheduling information, check email regularly, and be ready when the interview letter arrives. Once an interview is scheduled, move quickly. Schedule the medical exam with an authorized panel physician. Review the embassy instructions. Gather original documents. Prepare updated financial documents if needed. And do not wait until the last week to organize everything. A case can be delayed at the final stage if the medical exam is missing, the passport is not valid, original documents are missing, or the applicant cannot provide required evidence at the interview. The fifth important update is about the Trump-era adjustment of status policy. This is where applicants need to be especially careful. In May 2026, the Trump administration announced a major policy shift, saying many foreign nationals in the United States seeking green cards may be expected to apply through consular processing abroad, with adjustment of status treated more narrowly and as a discretionary benefit. This is one of the biggest reasons applicants need to plan carefully in July 2026. For decades, many eligible applicants inside the United States used adjustment of status to apply for green cards without leaving the country. But under the current policy direction, USCIS is placing more emphasis on discretion and may push more applicants toward applying abroad unless they qualify for adjustment under the rules and can show strong reasons for approval. This does not mean every adjustment case is impossible. It does not mean every applicant must leave the United States. It does not mean marriage green cards or family-based adjustment cases are banned. But it does mean USCIS officers may review more closely whether adjustment should be granted. So if you want faster green card approval under this environment, your case must be clean, complete, and well prepared. You need to avoid anything that gives USCIS a reason to delay, question, or deny the filing. That means forms must be correct. Signatures must be valid. Evidence must be consistent. Immigration history must be truthful. Medical exam requirements must be followed. Financial sponsorship must be strong. And any prior immigration violation or criminal issue must be handled carefully. The sixth important update is about signatures and filing accuracy. USCIS is implementing stricter signature rules in July 2026. Applicants must make sure their forms contain proper signatures. Copy-pasted, auto-generated, or unauthorized signatures can lead to rejection or denial problems. This may sound small, but it can make the difference between a case moving forward and a case being delayed. If a green card or visa-related filing is rejected because of a signature problem, the applicant can lose valuable time. In some cases, that delay can be serious if a priority date changes, a filing window closes, or a status issue develops. So, applicants should take filing accuracy seriously. Use the correct form edition. Use the correct fee. Sign in the proper place. Review every page. Make sure names and dates are consistent. Make sure translations are certified if required. Make sure copies are clear and keep proof of submission in 2026. Speed comes from accuracy. The seventh important update is about stronger vetting. Under the Trump administration, Immigration benefits are being reviewed more carefully, including social media history, family details, security concerns, and background information in some cases. This means applicants should expect closer review and should not assume that a weak or incomplete application will move quickly. For visa applicants, this can affect consular processing. Some applicants may face administrative processing after interviews. Some may face additional document requests. Some may face delays because of security checks or country-specific concerns. For employment-based applicants, employers and workers may need to plan for longer timelines and stricter documentation. So, while the title says faster green cards and visa approval, the real message is this: the fastest cases will usually be the best prepared cases. Under stricter vetting, poor preparation can create delays. Complete preparation can help avoid unnecessary problems. Now, who may benefit most from the July 2026 movement? Family-sponsored applicants inside the United States may benefit if their priority date is eligible under dates for filing, and they are otherwise eligible to adjust status. F2A applicants, including spouses and children of lawful permanent residents, should pay close attention because the category is current under the filing chart. Consular applicants at NVC may benefit if their documents are ready, and NVC is reviewing their submission date. Applicants who recently received USCIS approval may benefit if their case moves quickly into NVC case creation and document submission. Applicants with complete, accurate, well-documented cases may benefit because fewer mistakes can mean fewer delays. But who should be extra cautious? Employment-based applicants should be careful because July 2026 requires final action dates for employment-based adjustment filings. EB2 India and EB5 Unreserved India are under significant pressure, with certain categories unavailable in July. Applicants with unlawful presence, prior removal orders, criminal history, visa fraud concerns, or status violations should not rush into filing without legal review. Applicants thinking about leaving the United States for consular processing should be very careful. Leaving the United States can create serious immigration issues for some people, especially if they have unlawful presence or prior immigration violations. Immigration in July 2026 is moving, but it is moving under stricter rules. Applicants who understand the system, prepare early, and avoid mistakes may have the best chance of moving forward faster. Applicants who rush, file incorrectly, or ignore policy changes may face delays, rejections, or denials. So yes, there is a path to faster green cards and visa approvals for some applicants under the current Trump-era system, but that path depends on knowing the rules, using the right chart, completing the right documents, and staying ready for every step. That is all we have for this bulletin. We continue to share visa information and process updates for your U.S. immigration journey. It is important to understand United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will keep bringing you updates on U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas EB1, EB2, EB3, EB4, EB5, and family immigrant visas. If you have not already, please subscribe. Thank you for watching, and we will see you in the next video.